1170. The Answer.
Welcome back. You are listening to Whissel Wednesdays here on AM 1170, The Answer. My name's Kyle Whissel, your host with Whissel Realty. Before the break, we were talking with Lawrence Mudgett Safer Law about one of the craziest cases I've heard in a long time. So, Lawrence, you've kind of gotten us up to speed. We got up to the domestic violence charges. So take it from there. Where are we at?
Okay, so the restraining order issues in my client's favor. There's no temporary move-out order anymore. She moves back home. Okay, this isn't an instance of somebody breaking and entering or doing anything unlawful. There's no order of protection barring her from there. Her tenancy's never been severed. She had every right in the world to do that. So obviously, Fran Breslauer doesn't like that. They hire an attorney, finally, but instead of doing a 30-day notice, which is all this case ever was, is a 30-day notice case, they serve this. It's a 5-day notice based on a forcible detainer theory. Now, forcible detainer is never litigated in the courts. It's almost never used. It doesn't apply to the facts. And I can say I represent landlords all the time, and I deal with this issue all the time. A client comes into the office and says, hey, you know, I served this notice. Maybe I found something on the internet or I prepared it myself. I want this guy out yesterday. They're the worst person ever, yada, yada, yada. That's where it's the lawyer's job to be ethical and say, as much as I want your money, okay, I'm not going to file a case on this notice because it's not legally enforceable. That's not what happened here. So moving on, the complaint that was filed, here's a copy of it, okay? You can see it's over 100 pages long.
That's crazy!
I like that, Tracy Morgan. It's over 100 pages long for an unlawful detainer, right? They filed an amended one. This one is 73 pages long, okay? You've got almost 200 pages of complaints. Now, here's a copy of a complaint I filed for a landlord in this town the same time they did the amended one in July and got a sheriff's lockout first week of September. Could have been a little sooner. There were some clerk delays, but I think the point is clear. This thing's about 5 pages long. This case has always been about the drama. It's always been about the backstory. It's never been about just getting her out of the house, because if it was, they could have hired a competent landlord attorney back in December when they first claimed they wanted her out, had her out maybe at the worst February or March for $1,500 if she held over. So the next thing, you know, if you read any of the press stuff in the Washington Post and all these different media outlets, they have been very critical of me, of the court, of the California statutory scheme, they call it, for evictions, the judge. And I'm here to say that none of it's true. This is the first landlord-tenant case I've had in 10 years where the landlord is responsible for all of the delays in the case. Everything they've done, hundreds of pages of complaints, filing a peremptory challenge to get us out of the fast track department into one of the slower civil departments, all the motion work. Any landlord will tell you, you don't do that stuff. The name of the game is getting possession. If you file all these delay tactics, it's only going to slow things down.
Right. So the media is just looking for the sizzle, right? They're wanting to, like, what can we get people to tune in, listen to our channels? And they're selling, hey, there's a 90-year-old lady that has a live-in that we can't get out, that's causing issues. And that's what they're picking up. And then again, this is national news, and most of these media don't know about California law, right? And in California, we all know who live here. It is a lot different than any other state in the United States. California is very pro towards the tenant and not the landlord, and it's a lot different in other states. But that's something that I don't think they even talk about and bring up, and they're attacking you without even doing any research.
Well, that's the thing. I think they are doing the research, but they're not telling the whole story. They're just, like you said, the sizzle, the poor 90-year-old widow, and everyone can relate to this. I think everybody's had a landlord-tenant situation, or maybe a parent or grandparent who needed elder care and problems with a live-in. So I think it's relatable, and I think it really strikes a chord with people. To that end, I mean, The backlash has been brutal. I've been threatened. My clients received death threats, the neighbors pounding on the door, all this stuff. I mean, it's been, you'd think I was representing a murderer, quite
Right.
frankly.
And you were saying the online attacks, right? It's crazy with everything that's going on, and people have no idea.
No.
But it's definitely striking an emotional chord with most people that a 90-year-old lady's having issues with a live-in. But like you mentioned, the live-in is 72 years old. She's also an elderly senior citizen as well.
Who claims she was attacked. The officer's report supports that. She received an order of protection, but now she's been arrested for elder abuse from the same incident 8 months later after this case gets a little steam.
So where are we going at? I mean, we're wrapping up here, the segment. We're getting ready to wrap up the show. Again, you're listening to Whissel Wednesdays. We got Lawrence with Safer Law talking about an unbelievable national case that's right here in San Diego. What's the latest? What do you think is going to happen? Where are we at?
Well, I mean, that's a good question. I don't think they can win in the unlawful detainer court. I mean, I'm not the judge. I don't make the ruling, but I've been doing this 10 years, and based on their pleadings and ours and what the courts said, I've won 3 out of the last 4 motions. We've got 4 on deck. I expect to win them all.
Okay.
And
so October 2016, is your client still in the house?
No, she's been arrested, and the criminal court issued a restraining order, so she cannot go to the house. But look,
Where's she living now?
With family. But it's getting her back in isn't the end game,
right?
At this point.
No, at this point, it's getting what's due, right?
Exactly.
And that's she's been wrongfully taken out of the home that she was living in, had all her stuff. And that's what you're representing for her, is to make sure she gets what's due.
And there's 2 more
whole,
points.
Right?
I'm sorry?
And is made whole.
Right, made whole. But there's 2 more points I want to address. I know we're short on time. One, the hoarding. She was previously on Hoarders, buried alive with her ex-husband, and when the cameras were there, when the police opened the house with the daughter, who's also an attorney and associated in the case and loves her 15 minutes of fame here, they show all this property and they go, look, she's hoarding, she's trashed my mom's house, look what's happening. They fail to mention that the property they're showing doesn't belong to my client. It belongs to the Breslauers. They were in the middle of doing an estate sale. If you watch the news clips carefully, stuff is boxed, labeled, cataloged. There's green stickers of tape labeling, sorting stuff. They were in the middle of that process when she moved back home, okay? And they're just, nobody bothers to ask if it's even her stuff.
Again, it's the media slant, right? They want to sell the sizzle. They just want to get stuff out there. You're listening on 1170 AM. It's a very conservative radio, as you probably know, Lawrence. And a lot of us listening realize this is common going on everywhere, not just the presidential election, but many of these elections. They're selling what they want to sell because they are the people they want to get in, and it's crazy. So it's great hearing your story.
Lawrence, I'm curious. Would you say that a lot of this could have been avoided if they would have had proper documentation, if they would have brought somebody like yourself in early on in the stage to set up the documents early?
Absolutely. And I may have mentioned, $1,500, 30-day notice theory eviction, even if she held over, it would have been over in February.
Yeah.
It's always been about the drama. It's never been about just following the rules. There's a lot of family dynamics at play. It's a very common thing in these landlord-tenant cases. Everybody's emotional and fired up, and the key is let's separate the fact from fiction, the emotion from what's relevant, and just follow the strict protocols that are laid out. And if you do that, the landlord can win every time, even though it's a tenant-friendly state. Tenants can delay and there's things that can be done, but ultimately the landlord can always get their place back. You just have to follow the rules, and they have not followed any of them.
I love it. So if you want to get connected with Lawrence Mudgett, Safer Law, give us a call, shoot us a text, 619-663-SELL, 619-663-7355. Or if you want to get connected with any other guests we had on the show today, Leon Sandoval with Essential Edit, JC Agajanian with Whissel Realty, my co-host Jason Hall with Team Home Loans, or myself, Kyle Whissel, 619-663-SELL. Thanks so much for listening. We'll talk to you next Wednesday.
You just put your lips together and you come real close. Can you blow